Good evening, all. We, the associates of Ramanan Goyal and Company, are back again with some updates on real estate world. So we have two topics today. First is of lifting of corporate wheel, and which is a case of DLF in Odisha, which will be discussed by Vinayak. And second is the powers of RERA to deal with the directors in their personal capacity. So which one are we starting first?
Lifting of the corporate bill, right?
Right. So Vinayak.
Take it. So this is a very interesting case actually. This order was passed by ORERA in 2018, wherein DLF had undertaken a project, and they were issued the occupancy certificate in 2015, which is much prior to the implementation of RERA. However, this case has been brought up to ORERA, wherein this person called Gyanendra, Gyanendra Kumar Jena, he filed this complaint case against DLF, stating that Section 11 and Section 17, the responsibilities mentioned in those sections of RERA, will still be applicable on DLF because DLF has not complied to certain responsibilities under RERA. However, DLF has been given the occupancy certificate much prior to RERA. So this was adjudged by the authority, and ORERA was in view that what about those customers who have been facing problems because of a real estate project that has been promised to them to give those facilities and amenities, and has been given a particular carpet area has been promised to them, but the builder or the real estate developer did not comply to those promises and deviated from the layout plans. But those customers are not coming under the purview of RERA because RERA came in afterwards. And this real estate project was developed and had got the occupancy certificate in 2015. So by Section 3, if Section 3 of RERA, if a project is ongoing or has received a completion certificate, then it is not bound to be registered under RERA. So the applicability of the sections following Section 3 is not also applicable, is as per our understanding. However, in this case, ORERA said that even though there are multiple forums wherein the customer can go complaining about the developer because of the deficiency of services, he still can come to RERA because RERA is a wholesome act. It actually protects the interest of the consumers or the allottees, and therefore, even if the project is not liable to be registered under Section 3, and even if the project is out of the purview of the RERA Act, still those responsibilities under Section 11 and Section 17 will be applicable on the real estate developer. So this was the order passed in brief. Now, currently, this order has been challenged by DLF in the Odisha High Court, and the matter is still sub judice. We do not have a outcome yet. This matter is still in court. So that is the issue. So yes.
The order is prima facie liable to be dismissed because Supreme Court has already clarified that once a project is not liable to be registered, then RERA does not have jurisdiction on that project, right?
Yes, but when you see the rationale given by the authority is that the persons can go to a consumer court, can go to any other forum that is applicable, and even arbitration clause was in their agreement to sell, so they can also go under arbitration to resolve those issues. But ORERA welcomed the customer or the person who has been facing deficiency in service, stating that the responsibility of RERA Act that has been enshrined in the section is for the protection of the customers of any real estate project. It had widened the scope so much. I get that they have been limiting the responsibilities of the real estate developers only after RERA came in, like after 2017. But from a customer point of view, this was kind of developmental case study, which real estate developers should be aware of. I am not saying this is obviously this order will be dismissed on the grounds of the Supreme Court judgment. But we need to keep in mind that real estate developers have to take up some responsibility towards their customers, because authorities can sometimes widely interpret the laws.
New Supreme Court has already clarified the difference or distinguish between the retroactive applicability and retrospective applicability. So they stated that the project which are completed prior to the commencement of the RERA Act means that these projects are complete and they do not, require or they trigger the Section 3 requirement of project to be registered as an ongoing project. And only RERA will be applicable in the project which are ongoing at the time of commencement. So retroactive applicability was given to the projects under the RERA after which they came into force. So maybe because of that, this order is itself not maintainable because it is in contravention of the principle laid down by the Supreme Court in New Tech case, because it is trying to have a retrospective applicability, which the Act does not have, because the legislature has to provide an Act to have a retrospective applicability. Only after that they can have a retrospective nature.
Section 3 is the trigger point. Only after then those following sections will be applicable.
Correct. So until unless the legislature itself, after applying their prudence, apply that a legislature has to be in retroactive applicability. Until unless, I don't think so there could be a legislature to have that nature to be all together. So I guess
but still, I will forward this order. We can attach this in the video itself. Like we can give a link to the
definitely we'll do that.
the description section.
It is trying to have a larger impact in the real estate sector to include all the projects all together. But this will lead to a difficulty to the builders, because the project which are completed way back in 2010 or 2009 will itself also be applicable. So what responsibility, what liability could be imposed on a promoter when the project is already completed way back in 2000 or 2002 as well? If we are trying to have a retrospective applicability of the project in the real estate sector, then it will lead to the project that were completed in 1990 as well. So it will be a black hole type situation will be created, and each and every project that has been constructed will be under the scope of RERA. So it would be a little difficult to have that interpretation. But definitely we can see whether the occupancy certificate which was granted was valid or not, or as per the prescribed format, or maybe bylaws according that or not. If that's the case, or if it is false that it is the ongoing project, then only the RERA Act can have that applicability. Anything else?
But this judgment was about something lifting of corporate veil, na? So have
Lifting of corporate veil is basic principle, na, in which you have to find the director, that who is the responsible.
the person who is actually responsible.
That case first. Now we will be discussing the lifting of the corporate veil, the principle and the issue that we are facing. So I guess we've summed up. Or also, I think the DLF case the order was passed in 2018. Way prior, when the New Tech judgment came and it gave a.
Still is it pending in the High Court?
Still pending in the order.
They have challenged the order in the High
No,
Court.
the ORERA order was in 2018. Thereafter it was
But
challenged.
it's still pending. There is no means there is no order in between.
No. Only the ORERA order. There was no appellate. There is no OREIT order. They directly went to High Court challenging this order.
Challenging it.
Jurisdiction doesn't matter. You have to first approach the right forum or
No one High Court was entertaining the writs in case of overreaching of powers as well.
Yeah, in
maybe that particular time in some of the states, the appellate
appellate authority.
It's not that functioning. So could be a reason that why they approached
but
the
right
High
now
Court.
right now the High Court can give the direction that you have to approach the right court.
The case to appellate tribunal if they have bypassed the procedure that has been prescribed under the Act. But if they find that there is an onerous condition and there was no jurisdiction of the ORERA.
If ORERA has passed this order, then it certainly may have imposed some liabilities, na? So that
could have been a possibility.
You would have to comply with 43.
But
yes.
The order is without jurisdiction, it can be challenged before the High Court without going to appellate tribunal. Okay. So that's one of the case.
First, right forum, na?
If alternative if it is there, we have to definitely approve that. But if there's condition certain onerous, maybe in that the jurisdiction is very vast.
Then it does not become efficacious remedy, no?
Because first of all,
High Court rejects on the basis of alternative and equally
Alternative.
efficacious.
if it,
So if there is an onerous condition, how does it become equally efficacious?
because the order was passed without the jurisdiction, it's of a nullity.
Section 17 of the CTC talks about that you have to approach the right forum.
We have to approach
the right forum. But you are surpassing the authority, the tribunal, the appellate tribunal, you are surpassing, and then you approach the right the high court.
Chances for us to bypass the appellate tribunal. First of all, whether we have to see in 2018 whether the appellate tribunal was in functioning or not.
No. That's not the case.
Then
Suppose high.
efficacious remedy, then we have to prove that what was so the condition onerous on us that we could not fulfill, and the efficacious or alternative remedy, though it had provided in the act but is not available to us because the condition is so onerous. It's Ram Prastha.
One case is also the same issue, no? The authority passed the order and we approach the high court, not approach the tribunal. But in high court,
it's still pending.
Still is pending.
We are not aware of the outcome. What happened?
One of the advocates, the senior, said that you have to approach the right forum.
You see, in
Because the high court is not in view to accept that thing. Because if everyone approached like this, then there is a lot of burden to the high court now also.
Then we have to read it in the line of the Ram Prastha order that was passed by the Punjab and Haryana High Court. They stated that the jurisdiction is very vast with the High Court. If they feel that the condition imposed on the promoter is so onerous and it is unreasonable for him, onerous word was used, specifically onerous, then they can approach the honorable High Court.
Yes, high courts are entertaining the
Yes, courts are entertaining the writ, but okay.
Okay, now we'll discuss the lifting of the corporate wheel. What is this principle is all about? This is a company law jurisprudence that we have come to know, that the company and its directors or its shareholders are two different entities, and they both have their legal entity under the law. So the company will be known as a juristic person, and a natural person, its directors and the shareholder will be the natural person. So that two types of entity. For example, if a promoter is a company, XYZ Limited company, they have they have developed the project, and then a complaint was filed against them. The order was passed against the company. Then in the execution proceedings, the liability is casted on the director or its shareholders. How much that liability casted on them is valid, and whether the RERA, under the RERA Act, whether the authority can pass such an order is the issue which we are going to discuss. So first of all, there is a concept under the company law. First of all, that the company will enjoy a separate legal entity. It will be different from its director and the shareholder. Now, second of all, the question arises that when the company is a juristic person, it cannot work on its own. So it will be needing persons whose mind, whose body is being applied to, and on whose basis the decisions are being taken. So the second concept is lifting of the corporate will, which is the defense taken in major of the cases, that we will lift the corporate will and we'll see whether who was the person behind such decision or order, because of which the company acted in certain way. For example, non-compliance with the order. If the company XYZ company does not comply with the order passed by any of the authority or the tribunal, so is the real person behind that who is not complying with the order, or who is not doing certain actions which is required to be taken. So this is the lifting of the corporate wheel, that we lift the wheel of the corporate and see who is the person behind it. The jurisprudence behind this principle is that in the cases of fraud or collusion, wherein mens rea is involved, because the company cannot have a mens rea, it can only act on the basis of whatever its director and shareholders are working in particular aspect. So we'll discuss on this. So
the recent case which we are facing.
So currently we're facing a case where what happened was a lottee filed a case against the company only, not against its directors, and an order was passed. In the execution proceedings, the RERA authority directed the directors, company's director, to be physically present along with the details of the bank account of the directors, property details of the directors, bank account and property details of the company. As far as it is related to the company, we have to see what are the provisions that is to be invoked against the judgment debtor under CPC. But whether they can pass such an order against a director or not is the question, which the controversy that we are going to discuss. Because the company and the directors are both separate legal entity, and how can company's director or shareholder be personally liable for the acts of the company? So this is our question to be discussed here. So whether they can be liable or can be held liable or not. Binayak, any opinion on this?
See, as we discussed, like the concept of lifting of corporate veil, it means that that company is not itself as an entity liable for any wrongdoing. So a person running the company, person managing the company, or the person who is in the operational section of running that business has to be the person whom we can we can aim at. And lifting that corporate veil means ki the decision making process has arisen from a particular person, or the any incompliance has been done because of the wrongdoing of a particular person. So determining that on those ground, the person we can obviously um, summon the directors for any particular matter of the company.
Opinion on this, because the company can own property on its own name. The company is running business in its own name. Why the personal liability be casted on the directors or its shareholders? Otherwise, no one will be willing to be a director of a company. That's why the jurisprudence was brought in that the company and the directors are very different. In this, there is a landmark case of Salmon and Salmon, wherein there was stated that if the director is also a creditor of the company, he cannot be treated that it is the part and parcel of the company itself, and he cannot be a creditor. So they defined or they laid down the principle that the company and its directors are two different entities. They cannot be merged together, and the liability of the company is very different from the liability of the promoter or the director. By the lifting of the corporate veil is been promulgated is maybe for reasons, for in cases of fraud or collusion where the malice intention has been involved. For example, a company cannot commit a fraud, but a company can enter into a contract with any other person. In this case as well, the company entered into an agreement to sell the unit that they are developing within single allotment. Thereafter, the company failed because it can own asset in its name, it can do business, it can run business in its own name. So the liability is restricted only to the company. Also in CPC, what we can see is that the realization of the amount can be done from the judgment debtor. Judgment debtor is the person against whom the order was passed. And in this particular case also, the order was passed against the company only, not against his director. They were neither the party nor they were impleaded as a necessary party in the proceeding, because definitely they are the separate legal entities enjoying their separate entities altogether. So maybe for that reason, the personal liability of the director should not be imposed. But now we can lift that the company itself can comply or not can comply. The decision has to be taken from the board of directors or the directors itself. So they could have called or summoned the director for regarding asking them why they have not complied, but seeking the details of personal property of the director or their property is for the sole intent to be attached by that particular authority. So they cannot, usurp their jurisdiction and ask for something which cannot be done legally, because CPC also asked that the property of the judgment debtor can be attached, but they are not the judgment debtor, they are only the directors and the shareholders of that particular company. So in my opinion, maybe both of them are though different entities, they can only be summoned to question and answer why they have not complied with the order. But casting liability personally on them is altogether different thing, which the CPC also does not provide. Because the CPC only in cases of the partnership firm where the partners are only liable can ask whether the property of the partners can be attacked. But specifically with the company where it is an institution altogether, where it can run a business in its own name, own a property, do business, enter into a agreement with other parties. So in that particular case, liability per se cannot be imposed on directors or its shareholders.
Until the liability is ascertained upon any particular directors.
Unless they give a personal guarantee for that. Maybe they give a guarantee or they give an undertaking that I am being personally be liable if the company fails to do so, then my personal guarantee be invoked. In that case, definitely, because they have given their undertaking, or they affirmed to that action, if the company fails, then we'll do so. Then only we can impose the or cast the liability on them.
So in this case, they can
my
only
opinion
attach
is
the
concerned.
properties in the name of the company for execution of the.
Because CPC also provide that in case the judgment debtor fails to, the order 21 is specifically for the execution, and I guess rule 42 deals with that the property of the judgment debtor can be attached, and the procedure is that the decree holder will file an application. First they have to do a diligent search whether they can search for the company's property details, bank account details or not. When they fail after having a diligent or due diligence in that, after they fail, they can move an application, which was also not done in this case because it is a summary proceeding. The court suo moto took the cognizance because the company failed to execute the order, so necessary direction be passed against the directors and shareholders to bring in the details of the property and bank account details of of the director as well as the company. So this they have breached the process, though it is a summary proceeding. CPC does not apply on RERA authority or under the RERA Act, but still, if they are following the procedure that has been followed under CPC, then they have to due process to be followed. Maybe the procedure established by law may be followed in this particular matter, or maybe application would have moved or could have been asked for this. Anything else to it?
I think all being said, the liability, if talking about real estate field particularly, if there is a promoter, then of course everything is being promised by the promoter, then it's his liability because the company has its own liabilities and assets. And when the company has a liability there, then it is to be paid by the company. However, the lifting of corporate veil is only required when there are some things which a company cannot be expected to do. Similarly, like any misrepresentation or committing of an offense. These things are not something which can be done by a company, because company, though a person is a juristic one, cannot have an ill intention or ill mind. There is always going to be a person behind that. So the purpose of lifting wheel when it was incorporated was that if anything is done which is of criminal nature or which is of fraudulent nature, which can only be done by a man for his individual benefit, then it is required to lift the corporate wheel, so that that person can actually be identified, that who was the person who was responsible for this kind of action to loot the persons. So in that cases only, I think the directors or whoever the person who was responsible for such action was liable, should be required. So apart from that, if there is any liability which comes through routine course of business action, then it is of course on the promoter or the company to pay it off. And otherwise, if it is not able to pay off its liabilities, then the only thing that we can do is go against the company in NCLT or whatever we have. But however, we can't say that the director or its employee is personally liable. That's what I believe. Until and unless any ill intention of any director is proven, until and unless any personal guarantee is given, I don't think any court can proceed with the directors or the company employees to set off the liabilities of the company.
Correct. Not in field man can lift the corporate fee. It's just an
But RERA is not
exception.
the authority to check whether if there is any wrongdoing, if there has been any fraud or ill intention or malice. So
That the directors are two different or separate entity. So where they are lifting or they are doing an exception to the general rule, they have to see whether the there are categories for the same. If they fall within those categories or not, only for the offense or where there is an ill intent of a particular person which could be seen, then only the lifting of the corporate bill could be done. They are doing it in a general or a routine matter, that wherever the orders are not being complied with, then lifting the corporate bill, summoning or asking for the directors to come before us to apprise why they have not complied with the order. So this is a general practice that they are adopting, and which is against the procedures established by law, so that they cannot do so. So we have challenged this order before the appellate tribunal as well. So let's see what will be the outcome. Then we'll discuss that what view the appellate tribunal is taking. Because in this particular matter, the stakes are of the directors and the shareholders. Otherwise, no one will be willing to be a part of a company to take the directorship or be a part of a shareholder, board or board of directors. Because specifically, the personal liability of the company is also imposed on them. It was the company who initially executed the contract with the allotee, because they were neither the party, they were only authorized on behalf of the company to make a seal and sign on behalf of the company. They neither never entered into the contract, they never promised anything. So how can a personal liability, for example, if there's an agreement between you and me, then the liability will be on both of us. We are the parties to the agreement, where the directors were never the parties to the agreement. They were only signatory on behalf of the company that they have given powers to by the board of directors. So in that case, personal liability should be, restricted to that matter, whether they can, see whether there was a offense committed, because RERA is a civil law, plus it is a summary procedure.
Summoning
no
people, the directors is only wrong to the extent until their offense is proven. Yes.
There has to be a malice intention, because companies act on behalf of the. Ultimately, what if we see that the company cannot act on its own? It needs persons to be acting to keep it running. So, whether there was ill intent, if any of the directors in the general course of business is doing anything to ensure that the company is running smoothly, then they cannot be held liable for the same if they're not complying because of the financial crunch, or the company itself does not have the finances to pay off the debts or any of the compliance with the order, because there was a refund or the interest order that was passed. So it could be certainly because of the financial crunch the company is facing, for which the director cannot be personally held liable. So that's our suggestion in this opinion made. What we can say that specific cases, this is the exception to the general rule, and only in exceptional circumstances this lifting of the corporate veil can be done, and not in a routine matter, which the many of the RERA authorities are doing. They are giving imprisonment, because the act itself, RERA Act, if we specifically see, if they're non-compliance, they only provide for two sections by the promoter, section 40 for issuance of the recovery certificate, and second, a penalty cost to be imposed on the promoter for non-compliance of the order passed by the RERA authority and the adjudicating officer. There is nowhere the provision of imprisonment or asking them to furnish their bank account details and any such other details. So when the act itself does not provide such power to be exercised by the RERA authority or the adjudicating officer, such order passed are without the jurisdiction and can be, to some extent be challengeable before the appellate tribunal. They have to driven their power from the act itself, no? That's why.
Got it.
Anything else to discuss? आप लोग पॉइंट डिस्कस करते हैं
नहीं भाई बता रहा था कि corporate we lift कैसे कैसे किस किस केस में ही कर सकते हैं. That's what we were discussing, that personal liability cannot be taken in every case. It can only be taken in case of either in case of personal guarantee or in case of collusion or criminal liability, otherwise not. So good discussion.
For the next session, we'll discuss ChatGPT. What was the history and what is not going on about.
Binayak will enlighten us.
Sure.
Okay, in the next session, we'll discuss ChatGPT. That's all. We'll end the session. Thank you.
Thank you guys. Bye-bye.
Bye bye.